on presidential elections. That's exactly what they're asking this court to do. Substitute this court for the Florida Supreme Court, and you have Bush v. Gore all over again. And that manifests itself in various different forms that the court has seen in our brief, and the court has already identified. I will not go through all of them. I will try to hit the high notes on some, but we'll rely on our briefs and not dropping or conceding arguments, but we'll rely on our briefs for those that I don't address expressly. Let's talk briefly about what the complaint is, as that has been, I think, significantly clarified with the reply brief. One, the parties are presidential electors, and they argue that that makes a significant difference. But what are the acts of the state? Not Fulton County, not mullahs in Iran, not dictators in Venezuela. What are the acts of the state that are at issue? And it's in the discussion about traceability in the Jacobson decision from the 11th Circuit where that gets flushed out really for the first time in the reply brief. And there are three. And they tell you, and I'll keep coming back to it, on page 20 of their reply brief, the plaintiffs describing the state say they picked the Dominion system. Their policies led to de facto abolition of the signature match requirement. Their regulation to permit early processing of absentee ballots is unlawful and unconstitutional. Those are the three acts of the state. Everything else is happening at a county level, period. And from that, they raise what appears to now be four claims. One is the Elections and Electors Clause, citing the absentee ballot opening rule, I'll refer to it as, the settlement agreement. They raise equal protection claims, saying that the violation of the Election Clause has led to a vote dilution and discrimination against Republican voters. They argue that due process is violated because they have a property interest in lawful elections, again, under the Elections and Electors Clause. And finally, they raise a pure state claim in federal court under a voter election challenge. What is the relief they seek? The court has identified it. Why do they seek it? The court is informed of this on page 25 of the reply brief. And it is if the court will not order a different result than what the certified election has, they seek it through another means. They say on page 25 that allowing the electors to be chosen by the legislature under the plenary power granted to them for this purpose by the Elections and Electors Clause. One way or the other, the relief they seek is judicial fiat changing certified election results. And to evaluate these claims, the court does need to consider aspects of law, and this is where the problem is. I'm going to keep going until you tell me to stop.
I'm sorry.
No, it's fine.
I don't know if the issue is more here or more forward. Just keep going.
Okay.
You're going to have to bear through it and listen until somebody fixes it.
That's right. I just, again,
It's really not $64
I've got three, I understand. Also got the loudest dog in America. But in any case, to evaluate the claims, you do have to look at state law. And because the plaintiffs raised Code Section 21-2, 522, and the statutes that surround it, those cases are important. It allows a challenge based on these grounds, and in fact, some are pending now. Misconduct, fraud, irregularity, illegal votes, and error are all grounds to challenge an election in Georgia. All of these issues can be brought in those cases. Those election challenges have to be decided promptly under 21-2, 525. And this is critical, the relief sought is not to declare someone else a winner. It's to have another election. This goes to the point that there's simply no authority for the relief that they seek. Turning first with that factual predicate in mind to standing, there's been a fair amount of briefing on whether the status as a presidential elector guarantees standing. The 8th Circuit said yes, the 3rd Circuit said no, and I think the 3rd Circuit's analysis is more persuasive. And to the extent that the plaintiffs say the 3rd Circuit did not consider their status as an elector, that's true. But the elector is not what gives you unique status. It's if the elector is a candidate, and that is expressed in the 3rd Circuit decision in the voting Bonnier decision, and we would suggest that that is the most persuasive and relying brief. But I do want to address two other aspects of standing that are more particular. One is that when they're seeking to invalidate a state rule or a consent decree that the state has entered into, or anything truly under the elections clause, the Bonnier case speaks to this as well. And it says that because plaintiffs are not the General Assembly, nor do they bear any conceivable relationship to the state lawmaking process, they lack standing to sue over the alleged usurpation of the General Assembly's rights under the elections and electors clauses. That is absolutely true here. The Wood Court, the 11th Circuit Wood opinion, says the same, citing Walker, because federal courts are not constituted as freewheeling enforcers of the Constitution and laws. And that is the injury that underlies all of their claims, which is why they lack standing. I'm not going to get into traceability as much because I think the most useful aspect of the traceability is the crystallizing of plaintiffs' complaints, and as I've indicated, the isolating of the state acts in particular. On sovereign immunity, I only want to highlight that a decision just came out in Michigan seeking very similar relief. We'll get you the site. It is Michigan, it's against Whitmer, King versus Whitmer in the Eastern District of Michigan. Walks through all of the issues in this case and rejects the claims, denies the relief. On sovereign immunity, they raise the point that under Young, you can only get prospective injunctive relief. That's not decertification. That is a retrospective, and so sovereign immunity would bar that. And they do seek to prevent the governor from mailing the results. That can be prospective, but there's just not relief for it. So that's all I'll say on sovereign immunity. On latches, the Michigan court also joined in with Judge Grimberg on latches in the Wood case.